Upon notice, may I, my lord, permitted to mention on matter, my lord. Section 34 application, my lord, it was partly hard once, my lord. At that time, my lord, there was certain discrepancy in the page number, so my lord, the hearing could not be concluded. I have already started the matter, my lord has heard me.
Not heard. I don't remember. Which matter is this?
My lord, 2015 matter, my lord.
Give the list, we'll see.
Lordship, may I seek the indulgence to mention on VC?
Just a minute.
A section 34 application, not for hearing, but it needs to be converted to a commercial division. It was filed prior in 2015 section 34. It was filed prior, but it's required to be converted otherwise the recent judgments only for the purpose of conversion.
May I have my lord's kind leave to mention that on the last occasion on Friday, Mr. Deepraj Basu was mentioning a matter of sale versus allied. When my lord was intimated that the hearing is going on 2 consecutive days, 13th August and 14th August. On that day, my lord had instructed my junior to come back and tell my lords as to what has happened on 14th August. So that my lords,
So the next week I had asked.
yes, Lord. So he was supposed to mention today, and my lord has asked him to indicate to you as to what happened on 14th August, as to whether the matter is kept for on some other day or not. But I had personally gone for the hearing. 13th, 14th, extensive hearing done. Next date is fixed for 31st August.
What do you want?
But only to indicate, my lord, because he would be mentioned.
Let's see when he mentioned.
Because
When he mentioned.
I have not got notice till now, and because my lord had wanted my
mention it,
junior
we'll
to
see.
indicate to my lords, therefore, my lord, I had come to
We'll see
mention.
when they mention.
Lordship, a
Very good.
36-2 application.
36-2 application.
Yes, Lordship.
It's already filed.
It's already filed.
Then why are you mentioning?
Upgradation, Lordship.
It will come.
Lordship, may I mention upon notice, Lordship, upon Lordship's selection, the matter was then sent for mediation. The mediation failed, Lordship. I'm praying for inclusion in the list, Lordship.
Maybe I'm mentioning for obtaining leave, my lord. I have filing an application in a disposed of matter, my lord. What is happening? They are asking for a fresh wakalatnama and fresh competency, my lord. The department has already endorsed that the wakalatnama and competency are already present in the department. But the masters
Application you're filing in a disposed of.
an application for recalling, my lord.
Application for recalling.
Yes.
In a disposed of matter.
Yes.
Get the wakalatnama.
Lordship, may I be permitted to mention one matter upon serving notice, Lordship, for correction of orders. On 12th August, my lord had passed court orders. Those are analogous matters. The last 2 matters have been wrongly mentioned in the cost title.
May I have my lord's kind leave to mention item number 126 of the monthly list. It's an application for withdrawal of sums deposited as security. May it be taken up on any day subject to matter. Item number 126 of the monthly list.
Let it come up in due course. What is the hurry? We'll see that. Call out the list.
May I, Lordship, mention in VC?
Yes,
I'm grateful, Lordship. This is Lordship Execution Case 68 of 23. On 1st of July 25, there was a stay on the 34 proceeding subject to them paying the occupational charges per day. They have stopped paying from September last year, Lordship, and are enjoying the stay of an award that goes back to 2015, Lordship. So we are seeking an early listing of that application and execution petition.
early listing won't be possible, Mr. Kohli.
I can only say, I know, Lordship.
Execution petitions, it's a very heavy roster, very heavy board.
Then maybe perhaps, Lordship, we can move an application and at
Yes.
least point this out. That might be more appropriate.
Yes.
I'm grateful, Lordship. Deeply obliged.
With your lordship's permission, I apologize. Can I mention a matter on VC, your lordship?
Yes, madam.
Your lordship, on 11th August, we had filed an application under section 34 on behalf of the Damodar Valley Corporation. My OR is in court. I'm being led by senior advocate, Mr. Abhinav Mukherjee. I'm just requesting, if your lordship's calendar permits, that the coming Thursday, your lordship, and the roster is for the section 34, it be taken up because the main matter is coming on 29th, your lordship.
First of all, no junior is here. And second,
Your lordship,
I don't see any junior over here.
Your lordship, I'm really apologetic. I was informed they are in court.
Yes.
Please.
Mention it some other time. Yes. Next.
Please.
Anybody else for mentioning? All right. Yes.
Listed matter, new motion item number 1.
My lord, this is that bank guarantee matter section 9 application. Matter has been, my lord, amicably settled. The bank guarantee that we were apprehending they will invoke, my lord, that has been discharged. If your lordship will only kindly record that item numbers 1 and 2.
So you're just withdrawing it. Why should I record any of your settlement which has taken place out of court?
No, no, settlements need not be recorded.
Exactly. I'm not recording anything. Learned counsel for the
Only
petitioner
Very
the
well, my lord.
withdrawing and there are no disputes between the parties.
Very well, my lord.
seeks to withdraw the present petition. The same is dismissed as withdrawn.
Lordship. Item numbers 1 and 2 both.
1 and 2.
Grateful, my lord.
Yes.
Another 3.
Not today.
Four. Once expedition to the arbitration is trying to expedite and resolve it. If the 6 months extension, the last extension was by
Page.
Sarkar's order of 5th of August 2020. Partnership.
Page
number 16. I know what you are, but he is trying to senior advocate is there. He is trying to resolve everything, partnership, family, whatever properties are there. Partner had also died. He is giving it.
Yes.
No, there's no objection. It's on the verge of being resolved in all likelihood. There are lots of talks going on, my lord. There are.
All right. The petitioner has preferred the present application. 29. This court, by order dated 5/3/2020, had appointed Mr. Shyama Prasad Sarkar as the sole arbitrator to adjudicate the dispute between the parties. Full stop. However, Mr. Prasad held many meetings. However, Shumanto Prasad. The first one.
No, second one is just.
Yes, that's what happened. However, he expired on 27/7/2022. Thereafter, this court appointed Mr. Shuman Kumar Dutt as the sole arbitrator to adjudicate the dispute between the parties by order dated 23/9/2022. Full stop. Thereafter, this court, by order dated 7/12/2023, 10/1/2024, 7/8/2024, 6/2/2025, and lastly on 5/8/2025, extended the mandate of the arbitral tribunal by 1 year, 6 months, 6 months, 6 months, and 1 year respectively. Full stop. Learned senior counsel for the petitioner states that the mandate is expiring on 7/8/2026, and the matter is at the stage of
Settlement, my lord. There are talks of settlement.
is at the stage of arguments. Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Considering the material placed on record and the submissions made by the counsel for the parties, this court is satisfied that no delay in the conduct of the arbitral proceeding is attributable to the learned sole arbitrator. Full stop. Having regard to the advanced stage of the arbitral proceedings and in the interest of justice, the mandate is further extended for a period of 6 months
8 months.
from
Lord,
today.
my lord, may I? My lord, instead of 6 months, if it may be made 8 months, then we'll not be required to come back, subject to whatever my learned.
8 for a period of 8 months, the learned sole arbitrator is affidavit of service taken on and notice of motion.
Deeply obliged.
Five.
I appear for the petitioner, my lord.
On the other side.
And this is the evidence.
Another 6.
May please, your lordship, back to appear for the petitions.
Other side, who's there? No adverse orders today. Not today.
Very good.
New motion section 11 and number 7.
But my application, my learned 27. Me edicte chole jot খুলে but And now the dispute raised by the respondent, this is a partnership dispute. Partnership deed of 1st July 2024. But the defense of the respondent is that the partnership agreement itself is forged and the signatures are not their signatures.
Yes.
And they have questioned the existence of the arbitration agreement itself.
Yes.
Now, before issuance of the Section 21 notice, there was no dispute whatsoever. After issuance of the Section 21 notice, they first give me a reply.
Yes, sir. You are arguing, Mr. Shonak?
Yes, my lord.
Yes.
After issuance of the Section 21 notice, they gave a reply, denied the existence of the partnership deed itself. Then they went ahead and filed a suit before the Learned City Civil Court, seeking a declaration that the partnership deed does not exist, is not binding on them, and that a previous partnership deed is binding on the parties. Various other parties or persons have also been made parties to that suit. Now, relying upon that suit and their averment in the reply to the Section 21 notice, they say that the arbitrator cannot be appointed and the partnership deed cannot be enforced at all. Now, I have used a rejoinder. In the rejoinder, I have annexed documents which show that they have themselves given effect to the partnership deed itself. They have shown me as a partner of the firm. They have filed balance sheets relying on the partnership deed. They have taken loan. As in the partnership firm has taken loan, showing all of us as partners. But I'll show you, Lordship, those documents. Now, in these circumstances, the Lordship is well aware, Lordship has held in many judgments that it is only a prima facie finding has to be returned as to whether there is any arbitration clause or not, arbitration agreement or not. No trial mini trial cannot be conducted at the Section 11 stage. Now, the partnership deed says that these are the partners who are parties to the Section 11 application. In the suit that they filed, they admit that on 1st July 2024, such and such persons executed the partnership deed. Then later on, they say that no, previous partners, she did not retire properly, and that is why this partnership was never executed, and the signatures are also different. Now, in that suit now, the previous partner, which they say did not retire properly, she has filed an application seeking deletion of her name by saying that I have retired from the partnership firm. Now, I am not a necessary party to the suit, and partnership firm got reconstituted on 1st July 2024. Now, given these circumstances, I would beseech your Lordship that since there is a prima facie existence of the arbitration agreement, whether it exists or not, whether they signed it or not, whether there is a forgery, may be decided by the arbitrator. And I'll rely on only one judgment on that, but before that, I'll show your Lordship the documents. May I file my rejoinder, my Lord? I've served it on my learned friend.
You have got the rejoinder?
Yes. Opposition to
At page 25 of the application is the partnership agreement. Kindly sees the parties to the partnership agreement at page 25. Rakesh Chaudhary. He was always the partner of the partnership firm. Second is Uma Devi Kejriwal. Uma Devi Kejriwal was the new inductee in the 1st July 2024 partnership. And third is Romit Majumdar. He is the respondent number 2. His predecessor in interest retired from the firm. Then, my Lord, kindly sees, I'll not trouble your Lordship with the other clauses. Kindly sees the arbitration clause.
Expired, not.
Yes, I'm so sorry. Romit Majumdar's mother expired on 1st July 2024, and that is how the partnership was reconstituted. Kindly sees clause page 30.
She was not a partner, right?
She was a partner previously. Kindly sees page 33. Clause 25 is the arbitration agreement.
That is Mitali Ghosh Majumdar.
Yes. Clause 25 is at page 33 is the arbitration agreement. Each nominee by each partner. Then, my Lord, I'll not trouble your Lordship with the details of the disputes. There are disputes with regard to the furnishing of the books of accounts, unauthorized loans being taken, etc. Now, my lord, I serve a section 21 notice that is received. There is no dispute. I'll show your lordship the reply to the section 21. And it takes page 68 of the application. On paragraph 2, they say at page 68, they say that 3rd March 2022, a deed of partnership was executed by Rakesh Chaudhary, who is the respondent number 1 here. Srimati Mitali Ghosh Mujumdar, who is the mother of the respondent number 2. And Srimati Shita Kejriwal, wife of Vivekananda Kejriwal. Now, the petitioner is the mother-in-law of this Shita Kejriwal. And thereby a partnership business under the name and style of CRISPR Biopharma Incorporated was started. It is pertinent to mention here that during initiation of the partnership business, such and such, at all times relied upon the statements made by such and such. These are matters of trial, I'll not travel. But kindly, straight away comes to paragraph 5 at page 69. It is pertinent to mention here that Mr. Vivekananda Kejriwal promised and assured that upon putting their signatures on the every pages of the said deed, he will collect the signatures of Mrs. Uma Devi Kejriwal, who is the petitioner, and Srimati Shita Kejriwal, and believing and relying such assurances, my clients duly handed over the said deed of partnership dated 1st July 2024. So there is a partnership dated 1st July 2024 to Mr. Vivekananda Kejriwal for collecting the signatures of the said Mrs. Uma Devi Kejriwal and Srimati Shita Kejriwal. Thereafter, the said deed of partnership was notarized on 1st July 2024, and all such acts and deeds were completed by the said Mr. Vivekananda Kejriwal. But this is a clear admission of the execution of the partnership deed dated 1st July 2024. Then comes paragraph 7, where there is a dispute. That my clients, upon scrutinizing the said partnership deed dated 1st July 2024, it has been detected that signature of Shita Kejriwal is absolutely different from the signature put in the partnership deed dated 3rd March 2022. Inasmuch as the other documents, at the same time, the signature of Uma Devi Kejriwal is also different from the signature put in the government documents. Accordingly, the said partnership deed dated July 1, 2024 is fabricated, and the same is not valid in the eye of law. Therefore, the deed of partnership dated such and such is a void document, and you cannot seek any relief under the provisions of law. So, the respondents here have disputed my signature, saying that my signature is has been differently affixed in other old government records, and that is why, since the signatures are different in this deed, so I cannot rely on it. Now, the petitioner says this is my signature. Who is the respondents to say that no, this is not your signature and the signatures are different? And this usually happens when it is very normal for having two different signatures at two different point of time in life. And even one day I make one signature, second day it may differ. Some strokes can differ. Then this is the ground taken in the section in reply to the section 21 notice. Then comes the suit. Suit was instituted on 16th April 2026 after this reply was issued.
And this letter is dated?
This letter is dated 30th March 2026.
Where's the date?
The date is...
Yes.
Left-hand side at page 6.
Yes. Then kindly take the plaint of the suit that they filed at page 72. One is the partnership firm. Second is the respondent number 1 here in this section 11 application. Different number 1, Shita Kejriwal, who was the erstwhile partner. Different number 2 is the petitioner here in the section 11 application. 3 is the son of different number 2. And then 4, Ramit Mujumdar, who is the respondent number 2 here in section 11 application. That kindly sees page 74, paragraph 5. Accordingly, on or about 1st July 2024, another deed of partnership was made and executed by Rakesh Chaudhary, Mrs. Uma Devi Kejriwal, Ramit Mujumdar, pro forma defendant, and Shita Kejriwal. All the 3 parties to the partnership agreement, execution is admitted. Then they go on about the difference in the signatures and whether the previous partner really resigned or not, Shita Kejriwal really resigned or not, etc. and they have sought a relief. Reliefs are at page 78. Okay. They have said deed of partition in some portions, which would be deed of partnership. The reliefs are at page 78. Decree for Lordship is there at page 78. Declaration that signatures of different numbers 1 and 2 is not genuine. Deed of partnership is invalid, void in the eye of law. Then deed of declaration is not properly executed. Deed of declaration, partnership deed does not sustain, enforce. Decree of declaration that the defendants are not entitled to claim. All these reliefs are claimed after issuance of the section 21 notice. Now, what they omit to mention in this plaint and as well in the reply to the section 21 notice is that the partnership firm has filed balance sheets. In the balance sheet, they have shown me as a partner. And he takes my rejoinder, page 44. May I also mention that although it will not have a bearing on this case.
Rejoinder page, last page is 34. 44.
Last page is 57. Yeah. Well, apart from filing this suit, they also moved an interlocutory application and interim order was refused. This will not have a bearing on this case, so I'm not showing that. Page 44 is the balance sheet that they filed. Kindly see at the bottom of the page, 2 signatures would appear on the right-hand side. 2 partners, respondent number 1 and respondent number 2. These are the signatures of the 2 partners. I was left out. The petitioner was left out. Kindly see page 48 and 49. Lordship has page 48. The second table on top of the second table, partners capital account as on such and such. First name is Uma Devi Kejriwal, the petitioner. And there are only 3 partners. 3 partners, all 3 of them are parties to the present proceedings. They say that there are other partners to the partnership firm in the partnership agreement of 2022. Why didn't they show it? Page 48 and 49 may be highlighted in your Lordship's copy. I do not know. Page 49 is highlighted. Very well. In a similar manner, the bottom table, partners current account as on such and such, 3 names of 3 partners are given. Then Kani takes page 52. A loan was taken by the partnership firm from the ICICI Bank. What you will see on the left-hand side, borrower name CRISPR Biopharma, which is the name of the firm. And on the right-hand side, what you will see signers. Romit, Rakesh, Uma Devi, Simran. Simran is the employee of the bank and the other 3 persons are the partners who had signed the loan document. And then comes page 53 is the application by Sheeta Devi Kejriwal, whom they say there is a part of the partnership firm. She has filed an application in this suit saying that she is not a necessary or proper party because she has resigned. And he sees page 55, paragraph 4. Petitioner is not interested in the said business and she is not interested to get any benefit or profit for the period after retirement with effect from 1st July 2024. Neither a necessary nor a proper party, improperly joined. Prayer is made for striking out her name. Now, in this factual scenario, may I only rely on, but what we can see from the documents on record is that they had admitted the existence of the partnership agreement on diverse occasions. They have filed balance sheets showing me as a partner. they have taken loan or the firm has taken loan showing me as partner on the basis of this partnership deed itself, because I was not a partner before 1st July 2024. Prima facie, my lord, it seems, my lord, that there is a partnership deed between the parties executed. Now, whether it was signatures are different, whether it was on a non-judicial stamp paper of adequate stamp duty or not, those issues will be decided by the arbitrator. My lord, these cannot be done without a trial. Now, my lord, may I, in support of the contention, may I rely on a judgment of this court, which is upheld, which has been upheld by the Honorable Supreme Court. It is unreported judgment. I've taken a printout from Manu Patra. Paragraph 3. By a letter dated such and such, the respondent replied to the said notice and denied the existence of the termination agreement, alleging that the agreement was forged and fabricated. This is the same ground taken in this matter. Now, my lord, kindly, my lord, the court records the submissions of the parties. Then, my lord, from paragraph 14. The internal page 3. Heard the parties. Termination agreement contains an arbitration clause. The notice invoking arbitration was also issued. Annexure G to this application indicates that the respondent had proposed a draft of the said agreement, which was sent by email to such and such. Annexure H is an email containing resolution of the such and such. The contention of Mr. Dotto that the said termination agreement was not signed by the parties is to be decided upon appreciation of evidence. The allegation of fraud or fabrication, etc., is within the jurisdiction of the arbitral tribunal. This can also be decided as a preliminary issue. Respondent can make such a prayer. The petitioner has narrated in detail as to how the said agreement was signed by the parties. The petitioner also relies on an email dated such and such. The objection of Mr. Dotto cannot be decided without evidence. The objection with regard to existence of the arbitration agreement will include the aspect of validity of an arbitration agreement, albeit the court at the referral stage will apply the prima facie test. In case of debatable and disputable facts, the court will ask the parties to abide by the arbitration agreement, as the arbitral tribunal has primary jurisdiction and authority to decide the disputes, including the question of jurisdiction and non-arbitrability. The restricted and limited review by the referral court is to check and protect parties from being forced to arbitrate when the matter is demonstrably non-arbitrable and to cut off the dead wood. The court by default will refer the matter when contentions relating to non-arbitrability are plainly arguable, where consideration in summary proceedings will be insufficient and inconclusive, and when facts are contested. This is not the stage for the court to enter into a mini-trial or elaborate review so as to usurp the jurisdiction of the arbitral tribunal. The court must affirm and uphold the integrity and efficacy of arbitration as an alternate dispute resolution forum. But then, the court proceeds to appoint an arbitrator. Now, this order was upheld by the Honorable Supreme Court. The Supreme Court held that this issue may be decided as a preliminary issue. Now, with a preliminary issue on facts and law, a trial can also be conducted. Only one page. We have heard learned counsel appearing for the petitioner. The primary contention on behalf of the petitioner revolves around the alleged forgery or genuineness of the agreements containing the arbitration clause. In this regard, the High Court in the impugned order has already held that the issue of genuineness or valid execution of the subject agreements can be taken up as a preliminary issue by the learned arbitrator. It has been stated that the learned arbitrator has already commenced the proceedings. The petitioner shall therefore be at liberty to raise all the contentions before the learned arbitrator. We request the arbitrator to consider such submissions, preferably as a preliminary issue, especially if petition is disposed of. So, my lord, here, apart from the judgment of this Honorable Court merely, my lord, recites or records what has been held by the Honorable Supreme Court in Vidyadrolia and thereafter in various other judgments. I will not trouble your lordship with all those. Now, these are my respectable submissions.
Thanks, my lord. First, in the suit which was filed on a prior date than this, my lord, Section 11 application, my lord, my learned friend had filed an application under Section 8 for referring to the application. That application is pending. My lord, so long the application is decided and my lord, it is court comes to a prima facie consideration that the suit is not maintainable. As of today, the Section 11, my lord, is
your application is pending.
Yes, premature.
After they file the suit, after I filed the Section 11 application, I filed the Section 8 for referring.
Forward. So long, my lord, as the
Section 8 is only for reference of the parties to it. That has got nothing to do with the
My
appointment of an arbitrator.
The application is pending. There has to be.
court has to first come that my suit is not maintainable.
I'll show the provision of Section 8. It says it has got nothing to do with the appointment of the arbitrator.
One that is pending. So long, my lord, the learned trial judge, my lord, civil court doesn't decide, my lord, on the merits of the Section 8 application. My lord, Section 11 is, my lord, on the appointment. My lord, my learned friend and my lord, I both the my lord, contesting parties, my lord, cannot, my lord, go, my lord, claim the same relief before two, my lord, parallel forums. Therefore, my lord, as of today, my lord, Section 8 has to be first disposed of. Before disposing of Section 8, my lord, and admittedly, suit was, it's not, my lord, a manufactured suit, my lord, that's that after, my lord, Section 11, the suit was filed. No, suit was filed prior. Then, my lord, Section 8, then, my lord, to avoid, my lord, regards of Section 8, my learned friend had filed Section 11. One. Number two, my lord, kindly see, my lord, my reply to the Section 21 notice, my lord, which is at page 68 of the application. March 2026. Now, my lord, two things. Initially, my lord, due to, my lord, good, my lord, under, my lord, the relationship between the parties, my lord, kindly see paragraph 5. My learned friend has placed, me. Kindly let me, my lord, let me place it again. Kindly see, my lord, paragraph 4 and 5. First, on or about July 1, 2024, Mrs. Mitali Ghosh Mojumdar died. As such, she became the deceased partner. Accordingly, her son, Shri Romit Mojumdar, my lord, who is respondent number 2 before your lordship, was incorporated as incoming partner and the said firm at that firm, and at that time, same time, Mrs. Sita Kejriwal retired from the said partnership with effect from July 1, 2024, and Srimati Uma Devi Kejriwal, mother of Mr. Vivekanand Kejriwal, kindly marks, my lord, this name, Vivekanand Kejriwal, was incorporated as incoming partner of the said partnership business, as a result of which Sri Rakesh Chaudhuri, Uma Devi Kejriwal, and Romit Mojumdar became the partners of the said partnership business. Admitted. Then, my lord, kindly see, it is necessary to mention, my lord, kindly see, my lord, next paragraph 5, that Mr. Vivekananda Kejriwal promised and assured that upon putting their signature on every page of the said deceased, means his wives and mother, one is outgoing, one is coming, he will collect the signature of Mrs. Uma Devi Kejriwal and Srimati Sita Kejriwal, and believing and relying such assurance, my client duly handed over the said deed of partnership on July 1, 2024 to Mr. Vivekanand Kejriwal for collecting the signatures of the said Mrs. Uma Devi Kejriwal and Srimati Sita Kejriwal. Thereafter, the said deed of partnership was notarized on July 1, 2024, and all such acts and deeds were completed by Mr. Vivekanand Kejriwal, Vivek Kejriwal. Therefore, we believe the signatures, we handed over the document after signing by other parties to Vivekananda Kejriwal. He assured us that he will get his signatures of his mother and the wife and will hand over to us. And during that point of time, we did not discover the fraud. That's why it was case of admission. Then, my lord, we have clarified, kindly see 6 and 7. Kindly see. Needless to mention that at all times, my aforesaid clients relied and believed that Mr. Vivekanand Kejriwal, in all respect, and as such, there were no occasion that any suspect was cropped up in the mind of my aforesaid client at any point of time, because we relied upon Vivekanand Kejriwal. Then, my lord, that my clients, upon scrutinized the said partnership deed on July 1, 2024, it has been detected that signature of Sita Kejriwal is absolutely different from the signature of the partnership deed dated March 3, 2022, in as much as the other documents, and at the time the signature of Uma Devi Kejriwal is also different from the signature put in the government documents. Accordingly, the said partnership deed dated July 1, 2024 is fabricated, and the same is not valid in the eye of law. Therefore, the partnership deed dated 1st of July is a void document, and as such, you cannot seek any relief under the provision of law. It was then, my lord, we discovered that their signatures were not telling. Then, my lord, we raised, my lord, suspicion on the acts of Vivekanand Kejriwal. One. then that is why Millard, we are disputing Millard the existence of the agreement itself, deed itself. Now Millard kindly takes up Millard the rejoinder which my learned friend had Millard relied upon Millard paragraph pages Millard 48, 49. My lord has got it, Millard. Kindly see, the Sita Kejriwal is one of the name of the partners. As on, Millard, kindly see the partner's capital account was 30th June 2024, and the next one is 31st March 2025. Kindly see, Millard, 30 and on the next Millard partner's capital, Uma Devi Kejriwal was also there. Why, Millard, they were shown as partners? Because as on Millard 1st of July, Millard 2024, Millard, we did not have Millard anything to raise suspicion on them. These were prior documents. Our suspicion was when we issued this, not that we verified the documents thereafter. Before that, we did not raise any suspicion. We thought that it was a genuine document. That's why, Millard, these names were there. Then, Millard, kindly see, Millard, the page 49 again. Kindly see page 49. Again, kindly see the date as on 30th June 2024. This is before reconstitution. This is before reconstitution. Reconstitution was allegedly 1st of July 2024. Lordship has to kindly see, Millard, the dates. Therefore, our dispute, Millard, is all throughout. At that point of time, yes, we did not detect it. That's why Millard, we admitted them as partners. We did not detect that. When it was detected, we raised, Millard, the issue. Now, Millard, kindly see, Millard, next page, which was shown by my learned friend. Which is, Millard, page 52. Kindly see, Millard, it was signed by Uma Devi. His name is allegedly there. Millard, kindly see, Millard, that date 24th March 2025. Before, we did not, Millard, detect that at that point of time. We were under bona fide, Millard. We thought that that document of 1st of July was a genuine document. Now, Millard, kindly, Millard, this is one. Now, Millard, as of today, Millard, kindly see, Millard, the cost title of the Section 11 application. Kindly see, Millard, whether this can be maintained without, Millard, adding the firm as a party. Order 30, Rule 10 of the Code of Civil Procedure is a specific bar. He can be sued, but he cannot sue. Whether, Millard, without implementing the Millard firm, Millard, this can be at all maintained. One. Number two, Millard, in the...
Why the partnership has not been included?
Partnership firm is not a party to the agreement. It's the agreement between the partners to carry on the business of the partnership firm.
And what will be dissolved is the partnership firm.
Yes.
Everything is against the partnership firm.
It is against the partners to the partnership firm.
Whatever it is, ultimately it is the partnership firm.
Yes. A partnership firm will not be a party to the arbitration.
Why?
Because, my lord, I am not seeking any release directly against the partnership firm. It is against the partners. My grievance is
anything which is going to happen will have a bearing on the partnership firm.
Yes, I will seek for dissolution of the partnership firm itself. So, but in a Section 11 proceedings, it is only the arbitration agreement which will govern the parties.
Lord, I shall also be relying upon one judgment, my lord, that is, my lord, specifically barred under Order 30, Rule 10 of the Code of Civil Procedure.
Arbitration? Huh? No, judgment was
এটা লেকচার দিয়ে দিলাম এই যে বর্ণালী মুখার্জি এটা ওটাই দিলাম তো Lord, kindly see, my lord, the paragraph 2, my lord. এটা তো আচ্ছা একই জায়গা তাহলে আবার কি এটা মিলবে না কিন্তু কথা বলতে আচ্ছা ঠিক দেখছি না এই তো তোমার ব্রিফে রয়েছে Number 2, Miller, kindly see paragraph 2.
Yes.
that the present appeal arises from a partnership dispute in which the appellant claims to have claims entry into a firm by virtue of a document whose execution is stoutly denied and is allegedly to be a forged. The High Court, on the same factual foundation, involved the same the alleged arbitration agreement has in one proceeding directed the parties to resolve their disputes through arbitration, and whereas in other proceedings declined to appoint the arbitrator on the ground that the existence of an arbitration agreement is itself in serious doubt. The common issue, namely whether the dispute can be referred to an arbitration on arbitration or an arbitrator can be appointed when the very existence of the arbitration agreement itself is seriously disputed on the allegation of forgery and fabrication arises of a consideration in these appeals. Now, my lord, I will place further. My lord, kindly, my lord, sees, my lord, two judgments which my learned friend has relied upon. One by the coordinate bench of your lordship by Justice Sarkar, which was, my lord, affirmed.
Started with the proposition that it has to be a the partnership firm has to be a party. This is not.
No, this is not. This is not. This is on the fraud. This is on the fraud. Now, my lord, this is not on that point. But they have, my lord, first, my lord, Justice Sarkar's judgment, I have checked up, my lord. This, my lord, judgment was not considered at all.
Not considered me?
This was not, my lord, Justice Sarkar did not consider, my lord, these judgments or judgment of the Honorable Supreme Court at all.
It's 2026. So Sarkar's judgment is 2025.
Very well, Supreme Court. Very well. Kindly see, my lord, the order of affirmance by the Honorable Supreme Court. That is in 2026.
That's right.
My lord, that also did not consider, my lord, this judgment. Now, my lord, kindly comes to, my lord, this is, my lord, that's for consideration. My lord, now, my lord, kindly comes to, my lord, paragraph 18 onwards. 18, 19, and 20. My lord has got it, my lord, the special leave petition, my lord. Yes. The special leave petition, the petition filed against the said order was dismissed by this court, thereby lending finality to the aforesaid prima facie assessment between the parties in absence of any subsequent change in circumstances. While findings in section 9 proceeding is absolutely prima facie in nature, such findings, when they attain finality, cannot be ignored in subsequent proceedings founded on the very same issue. The prima facie satisfaction recorded by the High Court regarding the doubtful existence of the arbitration agreement was therefore a relevant consideration while examining the application under section 8 and 11 of the Act. And, my lord, here, my lord, Justice Sarkar had just said, my lord, taken the opposite view. The cumulative effect of the aforesaid circumstances lend considerable credence to contention of the appellant that the admission deed is not genuine. At the very least, the admission deed is under grave cloud of doubt, requiring a detailed and full-fledged inquiry. In the present case, arbitration clause does not exist independently but is embedded in the document whose existence is seriously doubtful. Arbitration, it bears reiteration, is founded upon consent. A party may be bound by the arbitral process only if it is first shown, even at a prima facie level, that such a party had entered to submit disputes to arbitration. When the arbitration agreement itself is alleged to be forged or fabricated, the dispute ceases to be merely contractual and strikes at the very root of the arbitral jurisdiction. Controversy of this nature falls squarely within the category of disputes that are generally recognized as non-arbitrable. Then, my lord, kindly see, my lord, paragraph 24. What is the ultimate conclusion?
Yes.
1. The dispute relating to the admission deed dated 17th April 2020 involves serious allegation going to the root of the arbitration agreement itself and is not amenable to the arbitration at this stage. The order dated 24th September 2020 passed by the High Court allowing the respondent number 1 application under section 8 of the Act is unsustainable and is hereby quashed and set aside. The orders, those are on the facts of this. Ultimately, it was held, my lord, 1. It is not arbitrable. And as of today, my lord, section 8 is pending. So long the civil court takes a decision whether the dispute will run before the civil court or it is arbitrable, my lord, this section 11 is premature.
May I deal
Any other judgment regarding
No,
partnership firm?
No, that is, my lord, order 30 rule 10 of civil procedure.
But insofar as the first point is concerned, that since the section 8 application is pending before the civil court, unless the civil court takes an opinion that there is an existence of the arbitration clause, section 11 can't. And he takes section 8, subsection 3 of the Arbitration Act. Section 8 is for power of referring the parties to arbitration. Kindly take subsection 3. Notwithstanding that an application has been made under subsection 1 and that the issue is pending before the judicial authority, an arbitration may be commenced or continued and an arbitral award made. So, my lord, it is not the proposition that unless the civil court decides or a judicial authority decides on the section 8 application, section 11 can't proceed, arbitrator cannot be appointed. This subsection says that even an award can be made during pendency of section 8 application, 8.1 application. No, my lord, this is the first point so far as the pendency of section 8 is concerned. My lord, even otherwise, when section 8 is only for referring the parties to arbitration, it's not for appointment of an arbitrator. Appointment, even the parties will still have to come before this court or mutually agree.
What about the judgment?
Yes. Now, my lord, so far as the judgment comes, my lord, kindly takes paragraph 4, the facts of this case. Here, in the judgment of the Honorable Supreme Court, the disputes as regards the very existence of the arbitration agreement was raised prior to the section 21 notice, much prior. Kindly takes paragraph 4. The appellant contends that the business of the reconstituted partnership firm was absorbed and taken over by a company namely such and such pursuant to the absorption deed dated such and such. On 2nd October 2016, the respondent number 1 issued a notice to the appellant asserting that on the basis of the aforesaid admission deed, she had acquired an interest to the extent of 50.33% in the erstwhile partnership firm, and the respondents had retired. The appellant, by reply dated 21st November 2016, categorically denied the execution of the admission deed by her or by the other respondents, and further denied the very induction of the respondent number 1 in the firm as a partner at any point of time. That is why the court held that since there is already a dispute with regard to the existence, this deed was never even executed. That is why the court held that no, once there is no deed, then it cannot be referred to arbitration. Alright, whatever has been laid down in this case, it has to be read with the facts of the case. On the contrary, in our case, there is a deed execution admitted. Deed has been given effect to, relied on by the respondents, admitted by the balance sheets. Then they say there was.
Suit was filed
by them.
By them. Section 8.
Section 8 by us. I have to file section 8 before filing any my first statement.
The outcome of the section 8.
But section 8.3 specifically says
that is subject
it cannot
to
await.
Subsection 1.
Yes, absolutely.
Exactly.
Notwithstanding, not subject to. It is notwithstanding. It is notwithstanding. That is the language. Then, on section 8.3, may I, Lordship, may keep it at 2 o'clock. May I come back with some judgments on this? Because 8.3 specifically says, notwithstanding that you have made an application, arbitration can commence and can go on, and award can be made.
Come back at 2.
Very well.
There is a resolution due to Mr.
Then, kindly keeps it tomorrow. We'll come.
Day after tomorrow, Milord.
Day after tomorrow.
Day after.
Rejoinder, The rejoinder filed by the petitioner is taken note of. Rejoinder to the affidavit in opposition filed by tomorrow. Any matter in both the sides are here?
In fact, next, my title 8 and 9.
Yeah, take your
We had to receive a offer from the petitioner for resolution of the dispute without.
Oh, yes, yes.
Yes. Yet we are yet to receive formal offer. It's out of delivery. They send it by post, so it's out of delivery. So we have not filed anyway. Not seek time to consider their offer if it reaches.
That has still not reached. So who's on the other side?
Mr. Ralrathan Mondal, I just spoken to him outside.
Where is
Mr.
he?
Ralrathan Mondal. He was there. 1 minute back he was there. I think he went out for something. So I can intimate him if Lordship pleases to adjourn the matter for today or keeps it any other day. I'll inform him immediately.
This is nothing. I will dismiss it. This is the one where he has to go to Mumbai, right?
No. Oh yes. Jurisdiction first.
No jurisdiction over
This
here.
court
We
will-
were only doing
He said they will try
we're
to
trying
resolve.
to resolve it. If it doesn't get resolved, we'll throw them out. And why it has not reached you? They didn't hand over a
According to them, they sent someone physically. That person could not deliver, so they then posted by
But they're
post
just
delivery.
wasting time.
So that's
They're
that.
just wasting time. This is not done. Day after tomorrow.
Day after tomorrow.
Keep this matter day after tomorrow. We'll whatever it is. This show he should have been here. We have
I
been,
have seen him inside the court.
We have been indulgent doesn't mean that he can.
I should be candid. I have met him outside. He also told me that
Any other matter where both the sides.
Item 19, well, both sides are here.
You'll do it?
But Lordship had asked us to take instruction for contempt.
But this is that matter, my lord, where
Well, Lordship's
leave
done
was
it.
taken from Bombay High Court.
Or you want me to distinguish that?
No. We don't want.
All-
We have consent. We have consent.
You have consent.
We have
Good.
consent. Lordship will keep open all points relating to validity, invocation of 21, invocation of the arbitration clause. All questions to be open to be decided by the arbiter.
Then 2 o'clock?
My lord.
Great.
The 28, 29, Lord, I am appearing for applicant. If anybody is there, Lord, I am appearing through VC from Delhi.
We'll only
If
ask to
anybody-
both the sides are there, so we have one matter, that's all. So we'll come back, we'll finish this.
Right. Okay.
May I have your lordship leave to mention?
Not at this time.
My lord, in the morning, Miss Payal Kakra has mentioned the matter and I was not there. I tender my apology.
Okay, to do it tomorrow.
My junior was there.
Not right now.
Tomorrow, my lord, should I mention it?
Tomorrow, whenever it is for mentioning, day after tomorrow.
Today is the mentioning day, my lord.
Day after tomorrow is also, I guess. No? Whenever is the mentioning date, you mention it.
Thank you for the petition. Lordship may keep all points open. Validity, enforceability, and the invocation of the arbitration agreement.
Where's your senior?
But he is unable to come today because of lack of transport.
This is an application filed under section 11(6) of the Arbitration and Conciliation Act, seeking appointment of a sole arbitrator to adjudicate the dispute and differences arising out of the loan agreement dated 21st August 2023, entered into between the parties. Where's the 21 notice?
The 21 notice.
Page 84.
Yes.
The petition respondent number 1 had a long-standing professional relationship, pursuant to which the petitioner was engaged as a consultant by respondent number 1 for a period of 12 months from August 2023, full stop. In the course of such relationship, the petitioner advanced a sum of rupees 99 lakhs to respondent number 1 under the aforesaid loan agreement dated 21st August 2023. The loan had carried an interest of 10.25% per annum and was repayable within 2 years i.e. by 20th August 2025. Full stop. It is the case of the petitioner that the respondents paid only the first quarterly installment of interest for the period January to March 2024 and thereafter committed defaults. Full stop. Despite various reminders and a notice dated 20th March 2025, followed by further correspondences between the parties, the outstanding dues remain unpaid. According to the petitioner, as on 20th of August, how much is the due?
Well, 99 lakhs plus 14 lakhs of interest, it comes to 1 crore 13.
As on 20th of August 2025, a sum of rupees 1 crore
11309,439.
11309,439
9,439.
comprising principal and interest.
Yes.
And accrued, principal and accrued together is the remaining outstanding amount due. Full stop. The petitioner thereafter issued a notice under section 21 of the Arbitration and Conciliation Act seeking invocation of the arbitral proceedings by notice dated 16/10/2025. The respondent replied to the said notice on 31st October 2025, stating inter alia that discussion between the parties were continuing, full stop. A further communication was issued by the respondent on 31st March 2026, raising certain allegations and seeking withdrawal of the arbitral proceedings, full stop. Learned counsel for the petitioner states that in terms of clause 7 of the loan agreement, the arbitration is the means of settling dispute between the parties. Full stop. The said clause does not expressly stipulate the seat of arbitration. Full stop. Though the petitioner had filed a petition before a Section 11 petition before the Mumbai court, but the same was withdrawn on 27th April 2026 for want of jurisdiction, with liberty to the petitioner to approach the court having jurisdiction. Full stop. Learned counsel for the respondent states that he has no objection to he does not dispute the loan agreement as well as the arbitration clause contained in the loan agreement. Full stop. The parties consent to appointment of an arbitrator to adjudicate the dispute between the parties. With the consent of the parties, Mr. Anyone?
Leave it to your lordship.
Any name? What about him? He's sitting there. Yes. Mr. Arnab Chaudhary is appointed. Give your phone number. Is appointed as the sole arbitrator to adjudicate the dispute between the parties. He shall be entitled to reference. He will enter reference in due compliance of Section 12 of the Act. He shall be entitled to remuneration in terms of the fourth schedule of the Act or with the consent of the parties. A copy of this order shall be communicated to the learned arbitrator to take necessary steps. With the aforesaid direction, the present petition stands disposed of.
But all points,
all contentions related to
the veracity,
arbitrability, maintainability, limitation, admissibility,
and whether
claim.
the directors can be made parties to the proceedings.
And I will not frame question. Everything shall be left open.
Yes,
to the learned arbitrator. All issues.
All issues relating to the joinder of parties may be kept open.
Issues relating to admissibility will cover.
Very well.
Shall remain open to the learned arbitrator. Adjudicator.
I'm grateful.
Any other matter where both sides are here? Otherwise, I'm not just going to call the list.
The item 25, I had requested my learned counsel for the other side to appear. Just had called him before your lordship decided.
So let's not call it today. He's not there.
I was just seeing if he was online.
I'm not going to run through the list.
I'm very sure it is this substitution application.
So we'll rest of the matters as it is on Wednesday. He's smarter than you.
Yeah.